Good day, Crime Talk aficionados. We have a great show for you today. First, the Delphi homicide case. It is in the hands of the jury. Bryan Kohberger's death penalty arguments are falling flat in front of the judge. We have an update in the Daniel Penny trial, this day in legal history, and our dumb criminal of the day. Let's talk about it.
Hi, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that little bell for notifications. And yes, you can check us out on any of your favorite podcasting apps. As you can see, we are back in the Crime Talk studios today. It was a long day yesterday, ladies and gentlemen. I drove 6 hours each way through a snowstorm to the other side of the state to go do a preliminary hearing that went for 2 hours. It was a continuation from the week before, and the judge found no probable cause for my client's charges. Therefore, free man. So it was well worth the drive. Got home about 8:15 last night, but I'm not complaining. It was a good day. All right, let's go ahead and pay a couple of bills around here. Ladies and gentlemen, if you have somebody coming into your life, you need to check them out. All right. And you need to do more than just a quick Google search. You need to go to crimetalksearch.com, get that background subscription service that you can cancel at any time. But while you have it, you can do as many background searches on anyone you desire. You could go do a background search on your boss, your neighbors, maybe the parents of the kids that your kids are hanging out with to see if there's something weird. Maybe don't want them to go over to sleepovers, which I would never recommend. And also, you're going to get this report emailed to you, literally prepared while you wait. And it's going to have all kinds of information about where they live, where have they lived, jobs that they've had. Do they have liens against them? Do they have judgments against them? Do they have criminal history, ladies and gentlemen? All the things that people are not necessarily going to bring out to you when they're trying to win you over, so to speak. Go check them out before it's too late. Don't commit dating malpractice. Don't commit parental malpractice. Go check everybody out. CrimeTalkSearch.com. All right, ladies and gentlemen, let's go ahead and get to the show today. November 7th, 2024. Can you believe it is already November? I cannot believe the year is almost over. It has been so busy. We have been busy. Lots of cases. All right, first, the Delphi homicide case. The jury has got the case right now. So both the prosecution and now the defense have made their closing arguments in the Richard Allen murder trial there in Delphi, Indiana, and the jury has actually started their deliberations. Now, they didn't deliberate long before they went home to their sequestration home, and they will resume deliberations in the morning. Now, Richard Allen, for those who don't know, is accused of killing two teens who went missing back on February 13th of 2017 and were found dead the next day. Richard Allen was arrested in 2022 and faced 2 counts of murder and 2 counts of murder while kidnapping in the deaths of Abigail Abby Williams and Liberty Libby German. This is a case that has captured the attention of everyone around the world. But of course, Judge Frances Segal did not think that we could handle the facts, so she did not allow it to be viewed by everybody via WebEx or through TV coverage. So, like I said, the fate of Richard Allen is now in the hands of the jury, 5 men and 7 women. Now, the state and the prosecution concluded their closing arguments early Thursday afternoon, and the case went to the jury about 1:25 p.m. Like I said, the jury's only deliberated for 2 hours before calling it a day. They will start again in the morning. Now, the Carroll County prosecutor, Nicholas McClellan, said in his closing arguments that the evidence the state has presented points to only one man, Richard Allen. Now, Allen, McClellan told the jurors, used his gun to force Abby and Libby off the Monon High Bridge Trail, down a hill and into the woods, where he killed them. He left behind his calling card, a bullet from his gun. Now, the state showed that Richard Allen is the bridge guy, McClellan argued. Said 5 years later, he lives in the city. 5 years later, he lives amongst us. McClellan recounted the many confessions Allen gave to prison officials, his therapist, and his family members while he was incarcerated at the Westville Correctional Facility. He played recordings of the phone calls that Allen made to his wife, Kathy Allen, his mother, Janice Allen, reminding jurors multiple times that Richard Allen confessed to the crimes of his own free will. The prosecutor talked about the single piece of physical evidence tying Allen to the crime scene, an unspent round found 6 inches from Abby's foot. Now, the Indiana State Police firearms examiner, whose analysis concluded that the round had been cycled through Allen's pistol, has never been wrong, the prosecutor argued. And Mr. McClellan talked about the 2 police interrogations leading up to Allen's arrest. On October 13th of 2022, he said Allen admitted wearing clothing similar to the bridge guy. And then on October 26, 2022, McClellan told jurors Allen had no explanation for how a bullet from his gun ended up at the crime scene. And Allen became angry and angrier as the Indiana State Police continued to confront him. Now, if jurors were still unconvinced, McClellan urged them to go back to one of Allen's confessions, the one where he was at the Westerville Correctional Facility. And he said that Allen told his therapist, Dr. Monica Walla, that he forced Abby and Libby into the woods and he planned to rape them, but he was spooked by a van driving on a private road nearby. Now, the vehicle, according to previous testimony, belonged to Brad Weber, who drives a white van and lives near the trail. And Weber told the jurors he was coming home from work around 2:30 p.m. on February 13th of 2017, a few minutes after the girls would have been forced down the trail and into the woods. That van, McClellan told the jurors, was a detail only the killer would know. What's more, McClellan said, an Indiana State Police officer who had become familiar with Allen's voice after spending countless hours listening to over 700 prison calls from him to his family identified his voice, Richard Allen's voice, as being the bridge guy. And in the infamous video that Libby took minutes before she and Abby vanished, the man who later became known as Bridge Guy was seen following Abby on the bridge. Something in Libby told her she needed to get out her phone and record it, the prosecutor argued to the jurors. And towards the end of the 43-second video, prosecutors say a man was heard telling the girls, "Go down the hill." That man's voice, according to the trooper, belonged to Richard Allen. Now, all of these pieces are clear, he argued, and all of the pieces are now put together. Now, the defense obviously gets to do their argument, and the defense attorney, Bradley Rozzi, urged jurors to recognize the dubiousness of the year-long investigation into the killing of Abby and Libby and acknowledge the dire prison conditions that Allen, who's still innocent until proven guilty, was forced to endure. He said you should question the credibility of the investigation because of those things they did not tell you, he told the jury. And over during the closing argument, Rozzi went back to what the defense viewed as a critical loophole in the state's versions of what happened to the teenager after they disappeared from the Monon High Bridge there on February 13th of 2017. A digital forensic expert testified earlier in the week that somebody inserted a headphone jack into Libby's phone at 5:45 p.m. and somebody removed it at 10:32 p.m. Nearly 5 hours later, the testimony from Stacey Eldridge cast doubt on the prosecution's theory that the girls were killed earlier that afternoon and that their bodies were left in the woods untouched until the first responders found them the next day. That phone has no personality, has no feelings, no opinions. It's just data, Rozzi said. Someone plugged something into that phone. Now, the state, Rozzi told juries, has had more than 7 years to investigate what happened during those 5 hours, but he argued at the end of the day, investigators and prosecutors preferred that jurors ignore the critical information that calls their narrative into question. And for jurors to accept the state's timeline of events, those girls would have had to have been kidnapped shortly after 2 p.m., killed less than a half hour later, undressed, and in Abby's case, redressed. They would have had to believe that one man who's 5'5" tall did all this by himself. Now, Rozzi told jurors, remember those investigators previously believed multiple people, not one, identified Richard Allen as the man on the bridge. Not one piece of digital data connects Richard Allen to the crime scene or the girls. Rozzi also said that there are no footprints or trace evidence like mud or blood in his car. Now, Rozzi pointed to what he views as the grievous mistake in the inept investigation. Police lost hours and hours of videos of interviews with witnesses. Investigators waited more than 7 years to conduct DNA testing on a piece of hair found in Abby's hand and to do a Bureau of Motor Vehicle search of a Ford Focus model in Carroll County. Prosecutors have alleged that Allen drove his black Ford Focus to the trail, pointing to surveillance video footage from the nearby Hoosier Harvest Store. Now, Rozzi cast doubt on testimonies from eyewitnesses who had various descriptions of the bridge guy. Not one of them fit Mr. Allen. Betsy Blair, Rozzi noted, described the man she saw as being youthful and boyish. Allen was in his 40s when the girls were killed. Rozzi also cited the testimony from 2 witnesses who were on the trail around the same afternoon the girls would have been forced into the woods nearby. David McCain and Shelby Hicks both testified that they didn't hear any screams. They saw nothing, heard nothing, and Rozzi's urging to the jurors to exercise using their common sense. Rozzi also questioned an Indiana State Police firearms examiner, finding that an unspent round found at the crime scene had been cycled through Allen's Sig Sauer P226 40 caliber handgun. He called it the magic bullet, and there's nothing more than a tragic bullet. Allen's actions shortly after the girls were killed and the day after leading up to the arrest don't suggest guilt, Rozzi argued. Allen self-reported to the police on February 16, 2017, that he was on that trail. And on October 13, 2022, and October 26, 2022, he willingly went to the police headquarters to be interrogated, Rozzi said, and on both occasions, he asserted his innocence. Now, Rozzi acknowledged that Allen grew angry during the second interrogation, but he said, if someone was bearing down on you for murdering 2 girls, your response would be the exact same way. Rozzi then turned to the conditions of Allen's incarcerations that drove a troubled man to a state of psychosis. And now Allen, who has a history of depression and anxiety, was taken to the Westville Correctional Facility back in November of 2022, shortly after his arrest. Mr. Allen was fragile egg when he landed at those doorsteps, Rozzi argued, adding that he was housed within and treated just like some of the state's most heinous criminals. Now, Allen lived in an 8-foot by 12-foot cell with cinder block walls and little human contact, he argued, and his outdoor recreation time was spent in another walled area with a net ceiling. When the dust settled, he was there for 13 months. How much can one person endure, he argued. Rozzi also tried to cast doubt on the testimony from the therapist, Dr. Walla, that he was faking his bizarre behavior. He reminded jurors that the prison staff injected Allen with antipsychotic medication. Antipsychotic means he's psychotic, ladies and gentlemen, he argued. Now, Rozzi ended his closing arguments by showing jurors photos of medieval torture devices used during interrogation. In modern times, he argued, torture is in the form of prolonged solitary confinement. When is somebody going to say something wrong here? Rozzi told jurors. Where is the moral compass? You are the moral compass, he urged them. Then he showed several photos of Allen in his cell. One showed him lying naked next to his bunk with his arms wrapped around the toilet bowl. That's the power of your government, he told jurors. No man or woman should be treated this way. Well, as in all criminal cases, since the prosecution bears the burden, they get the closing argument. They get the final rebuttal. And in his rebuttal, the prosecutor, Nicholas McClellan, said the defense has not backed up many of its claims. We've done that, he argued. The bridge guy video, Allen's confession that only the killer would have known, and Allen's own admission that he was on the Monon High Bridge Trail at 1:30 to 2:30 p.m. the day of the murders. Richard Allen said a lot of words to a lot of different people, he said, adding that he gave detailed confessions to his therapist because he trusted her. Words matter, he argued. McClellan ended by talking about Libby, who in her final moments took the video that became a key piece of evidence in this case. And he reminded the jurors of Becky Patty, Libby's grandmother, who said Libby's ambition was to help police solve crimes. She did that, Mr. McClellan ended. Well, ladies and gentlemen, when the verdict comes back, we will bring it to you. The question is, how long will it take? Do you think those jurors are thinking about it individually? Yes, they are. Do you think they're going to have a lot of time to think about it in their heads and then tomorrow come back and say, hey, anyone want to talk about anything? I think it's going to be a quick verdict, ladies and gentlemen. Now, I could be wrong. You never know what a jury will do, but that is my guess. And I have said it all along. The problem for the defense is the defendant's own statements. I'm telling you, For someone who's done this for 30 years, it's always the defendant's own words that get them in the end. And I think it may be what gets Richard Allen. Maybe it was truly psychosis. I wasn't there to see it all. But I'm telling you, everyday citizens generally have the position that people don't go around confessing the crimes they didn't commit. We'll see. We still give him the presumption of innocence, and we'll see what the jury decides. Next, the Bryan Kohberger matter. Yep, some of their arguments were falling pretty flat in front of the judge. So Bryan Kohberger, obviously accused of quadruple murder, received a little bit of a, warning from the judge that was newly assigned to his case as he tried to eliminate the threat that he could face the death penalty if he's ultimately convicted. Now, for those who may not have been following this case, Bryan Kohberger is accused of brutally murdering Ethan Chapin, Zaina Kernodle, Madison Mogan, and Kaylee Gonsalves in their off-campus house in November of 22 there in Moscow, Idaho. Now, in court on Thursday, his legal team has a lengthy list of reasons they think why the death penalty should be taken off the table in this particular case. Now, in the conclusion of the final last-ditch argument, which stated that the death penalty does not reflect the international law and modern-day standards of decency, Judge Stephen Hippler gave a pretty straightforward response. I understand that argument, he said. It's falling as flat as you would expect it to fall. Well, the judge has spent 4 hours listening to a host of reasons the defense opposed the death penalty in this case. While he was officially taken all of the motions under advisement, he questioned and pushed back on many of the claims that were made by the Kohberger defense team. Now, ladies and gentlemen, Kohberger's attorneys are doing what they're supposed to do. This is death penalty litigation. You're attacking the constitutionality of the death penalty, the changing standards, cruel and unusual punishment. That's what you do. All right? That's what you do. Are any of these motions going to be granted? No. They were making their record. The judge allowed them to make their record. They will all be denied. The death penalty is not cruel and unusual punishment under the United States or Idaho Constitution. A death penalty defendant gets super duper due process, more than anybody else would ever get because it is a death penalty case, right? And remember, the Fifth Amendment of the United States Constitution says the government shall not take your life, liberty, or property without due process. Clearly, the founding fathers, when they drafted the Constitution, understood that they could take your life, your freedom, your liberty, and your property, and you have to be paid just compensation for it. Why? That was a big thing that they had a problem with the king, right? He'd go and kill somebody and wouldn't give them their day in court. It's not going away. States can ban it if they choose to do so. It's still there on the federal level, which is not applicable in the Bryan Kohberger matter. But the fact that it has never been repealed shows, other than that very short time back in the early 70s, when the Supreme Court said it was cruel and unusual punishment, and then they reversed and said, no, it's not cruel and unusual punishment. I get what they're doing for Bryan Kohberger. They're being his lawyer. They're being excellent attorneys for Mr. Kohberger. But these motions are all going to be denied, and then ultimately a jury will decide whether, one, Bryan Kohberger is innocent or not guilty, and whether the prosecution proves their burden of proof beyond a reasonable doubt. Ultimately, a jury will decide whether Mr. Kohberger is worthy of the death penalty. That's for them to decide. Now, we'll give him the presumption of innocence because that is what he is entitled to. His attorneys are doing a good job, but to use the word of the judge, your argument's falling as flat as you can expect it to be. Next, update on the Daniel Penny case. That's right. Marine Corps veteran Daniel Penny is on trial for manslaughter in New York City after placing a homeless man by the name of Jordan Neely in a deadly chokehold on the subway back in May of 2023. Now, there was a 911 call played for jurors that a teenager passenger took the stand earlier this week, telling the police that the troubled Neely was trying to attack everybody before Penny put him in a chokehold. Now, the witness testified on Monday that she was so nervous as Neely was ranting and raving throughout the car that she thought she was going to pass out. She was that nervous. There's a guy on the train saying that he was ready to go to jail. He was ready to harm people on the train. And now Ms. Rosario, who made the 911 call, can be heard saying on to the call. So the guy he steps in and now he's holding him down. Ms. Rosario said the one making the trouble, making the harm, he's black. Rosario also took video of her cell phone that was shown to the jury Monday of the struggle. Now, after jurors were sent home for the day, Daniel Penny's lawyers made a motion for a mistrial. saying that the alleged incendiary opening statements and for allowing witnesses' testimony reinforced the narrative that Penny was a white vigilante. Now, the defense attorney for Mr. Penny said prosecutors repeatedly allowed witnesses Johnny Grima to refer to Mr. Penny as a murderer, and another witness, Morella Sanchez, to describe him as a white man during testimony on Thursday. Now, the defense attorney argued that the testimony, along with the opening statements made by the prosecutors, said that Mr. Penny was not getting a fair shake. Now, the defense attorney also accused the district attorney's office of trying to paint Penny as this white vigilante, and now the DA has put that right in front of them to reinforce this narrative, that this architecture student who served his country admirably, that was on the train with an unhinged nut job, according to witnesses, is a vigilante. There's no longer any way that his client can get anything resembling a fair trial at this point, given what happened. Well, Judge Maxwell promptly denied the motion for mistrial. First of all, when you're going to do your motion for a mistrial, you need to do it contemporaneously. You don't wait. You need to do it right there and right now. So that didn't quite work out, but the record has been made. Now, Daniel Penny was heard on an officer's body cam footage saying he had a chokehold victim pretty good. Mr. Neely, we refer to that. He had him down there pretty good. Anyway, a jury in earlier testimony today was shown a video taken from an officer Casey's body cam of Penny chewing gum while describing to the cop that what went down with Mr. Neely. I asked him if he saw what happened, and the officer said he had a conversation with Mr. Penny. Penny told the officer that Neely came on the train. He was throwing. He said he was ready to die and ready to go to prison. Yeah, he was just on the ground. He was trying to roll up. I had him pretty good. I was in the Marine Corps, is what he told the police officer. Now, the conversation was confirmed from the jury through the body cam video. Now, Mr. Penny could be seen standing over Neely's body for a while, watching officers perform and first responders perform CPR. After the lunch break, two other officers were called about 911 calls that came in about the Neely incident. And the jury also saw a video of Mr. Penny getting escorted to the precinct, though it was difficult to make out what the suspect was saying in the video. Now, a witness by the name of Johnny Grima testified that Daniel Penny told him to stop when he poured water on the forehead of Mr. Neely to wake up the homeless man that had been released, obviously, from that chokehold at that point. Grima, who has been homeless himself in the past, was riding the subway from checking on homeless people in the Tompkins Square Park. After the F train he was riding stopped, Grima walked up to the car where the commotion was and saw Penny had a grip on him. He finally did let him go, Mr. Grima testified to, but that Mr. Neely fell limp to the ground. Now, Grima interjected to say that Neely, who he didn't know, should be put on his side, and eventually poured some water on him, and Neely had to try to awaken him. We also heard from Caden Shrunk, and she was relieved when Daniel Penny intervened to take down Jordan Neely, because if this homeless man had gotten up, who knows what he would have done. She also described that Mr. Neely, who had visibly soiled sweatpants, started raving on the subway car, and it was the first time in her life she thought, I might die. She also said she didn't think that Penny looked like he was harming Neely. I didn't look like he was squeezing the troubles man's neck, and she didn't believe Neely's death would be the outcome of that day. Penny's lawyers have maintained that Mr. Penny sprang into action to protect riders and that he should not be held criminally responsible for the death of Mr. Neely. I'm telling you, I'm rooting for Mr. Penny in this particular situation, ladies and gentlemen. Normally we just try to call balls and strikes, but on this one, we're going for Penny. Give the man a fair trial. Let the chips fall where they may, but I think he did the right thing. And I think the big fact for me is the fact that Mr. Neely was alive when the officers arrived, and it looks like their lack of medical attention may have contributed to his death. I would find him not guilty. Anyway, I try to call balls and strikes, but on that one, I don't know. I think he stepped up. It takes a lot for people to do something good in today's world. And when somebody tries to do something with no intent to harm or kill somebody, and next thing you know, they wind up on trial facing a potential prison sentence, Just don't like that. Next on the docket, this day in legal history. On November 7th, 1916, Jeanette Rankin of Montana became the first woman elected to the U.S. House of Representatives, breaking gender barriers in politics. Her election paved the way for women's involvement in the legislative process and influenced subsequent gender equality movements. Also on this day, on November 7th, 1960, Washington, D.C. residents were granted the right to vote in presidential elections with the ratification of the 23rd Amendment. This was a landmark step for voting rights, allowing D.C. residents to participate in national elections despite lacking congressional representation. And on November 7th, 1972, the Senate passed the Equal Rights Amendment and sent it to the states for ratification. Though it ultimately fell short of the required 38 states for ratification, the ERA amendment sparked national debates over gender equality and constitutional rights. And on November 7th, 2000, yes, 24 years ago, ladies and gentlemen, Colorado voters passed Amendment 20, allowing medical marijuana use, which laid the groundwork for recreational legalization in 2012, and it made Colorado the first state to legalize recreational marijuana and initiated major changes in the drug policy across the U.S., which means just about everybody has legalized marijuana, at least for medicinal purposes. I think Florida just turned it down. In the past election, they said they didn't want recreational. It has been a roller coaster, I can tell you, here in the state of Colorado, ladies and gentlemen. There were literally flocks and flocks of people that came here just to smoke weed, to get their medicinal card. I've seen people arrested for a few plants, go to federal prison, represented clients that owned dispensaries, and they were rather candid. They're like, I'll either be in custody in 5 years or we'll have 12 Ferraris in the driveway. Well, I guess they gambled right because they cashed out big and they got a bunch of Ferraris. So it's a roller coaster ride, but there's a lot of people that have gone out of business. What do they say? There's the innovators, the imitators, and then there's the idiots. All the idiots got in late, and at least it doesn't smell like marijuana as you drive down I-70 anymore. It used to be so bad. Woo! And finally today, our dumb criminal of the day. Please meet Mohammed Abdullah Albalan. Now, this 27-year-old man from Pennsylvania was arrested on a petty theft charge for allegedly stealing a lap dance. Yes, our dumb criminal, cops say, was buying a service from a woman inside a Florida strip club when he refused to pay the $40 for the service. Now, Mr. Albalan sought to leave the Rain nightclub in Clearwater without paying at 2:45 a.m. Anyway, the deputies responded, met with our dumb criminal of the day, and the manager said, hey, he didn't pay us $40. He's been charged with misdemeanor theft. Mr. Albalan was booked into the county jail, for which he was released last night after posting a bond of $40. A judge has ordered him to stay away from the Rain Gentlemen's Club, which features 55 televisions, 3 full liquor bars, 30 private dance rooms, and several VIP suites. Mr. Albalan, you are a dumb criminal of the day. But we're probably going to have to throw in the young dancer as well as being a little dumb because you're always supposed to get your money up front. And then if they want to buy more, then you get more money. But you always get your money up front. Just like the criminal defense business, you got to get a retainer because once it's done, everybody wants to walk out and leave without paying their bill. All right, that's all we have for today, ladies and gentlemen. Have a wonderful day. We'll see you next time on Crime Talk. And remember, yes, that pesky Constitution, it matters.